Sorry.
Yes.
My Lord, I have submitted written submissions, which I hope your Lordships have got, of 12 pages. And there is a brief compilation. To the extent possible, I've tried to avoid. Not this were prepared on 2nd of May. So to the extent possible, I've noted the submissions and tried to deal with issues not dealt with. My humble request is, as I go along, if your Lordship feel this point is covered, just ask me to move on, because we have to, others also have to argue, my Lord. My Lord, I have basically 6 grounds in my written submissions. And if your Lordship takes page 1, my Lord, the first proposition which I wanted to make was, a lot was asked on, is there a fundamental right to marry? And my submission in my first part of my note is that, if your Lordship has got my note,
Yes.
the 3 cases, Puttaswamy, Shafin Jahan, then you have Navtej Johar, when they use the word right to marry, they really were meaning the right to cohabit, the right to live as a union. There was no concept of a marriage in the sense of the Hindu Marriage Act or the Special Marriage Act. Now, my Lord, the same-sex marriage, I did some research. I could find it only in para 479 of Puttaswamy of Justice Nariman's judgment, where, if your Lordship kindly sees at page 2, his Lordship says rights of same-sex couples, including the right to marry. Lordship has got the bold, yes. Now, this is a bit ironical because this judgment was delivered 1 year before Navtej Johar. So at that time, it was an offense. So it could not be a fundamental right to marry. So, but anyway.
No, but in Puttaswamy, we had expressly cast doubt on the judgment which overturned Nas Foundation.
Correct, Nas Foundation, yes. So in that sense, yes, but I'm just saying that this was recognized. Now, please come to para 126, 167 of Navtej Johar, where then, my Lord, the Chief Justice has set out what was the stand taken by the petitioners at that point of time. 1.3, Lordship has got 1.3. The above authorities capture the essence of the right to privacy. There can be no doubt that an individual has a right to a union under Article 21 of the Constitution. When we say union, we do not mean the union of marriage, though marriage is a union. As a concept, union also means companionship in every sense of the word, be it physical, mental, sexual, or emotional. The LGBT community is seeking realization of the basic right to companionship, so long as such companionship is consensual, free from the vice of deceit, etc., etc. Now, my Lord, what my submission is, when your Lordship says there's a fundamental right to marry or a right to marry, your Lordship is basically declaring a law, and I'm going to come to what is the status of a court declaring a right when I come to the 6th part of my submission. But now, once your Lordship says, for example, in Navtej Johar, that you decriminalize a gay relationship, from that time onward, the law declared by the Supreme Court says that it's no longer a crime to have a same-sex union. And that's what it stops. Now, but to go one step further is a totally different aspect. Now, once the court says that a same-sex union is not illegal, is not a crime, from then on, any legislation cannot say that if 2 people of the same sex cohabit, it will be an offense. That's the law declared by the Supreme Court. Unless that law is changed by an amendment of the Constitution, that will be the mandate. And I give you examples where once your Lordship declares the law, and Lordship will kindly see Article 13(2) says law includes. It is not just Act of Parliament, notification, regulation, custom having the force of law. I would say a law by Parliament is X. The interpretation played by a Lordship is Y. And X plus Y will become the law declared by Parliament in future. Now that can be changed as per Prithvi Cotton Mills by reviewing the basis of the judgment and so on. But once your Lordship says there's a fundamental right to marry, It is a recognition that they have a right to cohabit. It was not used in the sense of marriage as in the marriage law. That's the first proposition I'm making. Now, my lord, I've just given examples of how the parliament has overcome judgments which it did not find, like, for example, whether in reservation cases or in 46th Amendment, etc. When Supreme Court said, yes, you can't levy tax on works contract, they made the 46th Amendment. When they said you can't cross 50% limit in promotion, they made it. EWS. It was said that economic criteria is not a criteria. Mandal said that. Indira Sawhney's case. But Lordship
Which one of them relates to a fundamental right?
Pardon me?
Which one of them relates to a fundamental right?
I beg your Lordship.
Which one of these relates to a fundamental right?
The right to marry.
No.
Fundamental right.
You see, when you're giving these examples, A, B, C, D, E,
Yes, yes.
none of them actually relate to a fundamental right.
No, I'm not saying that.
Dunkerley or
I'm saying what's the law declared by Supreme Court. Lord, I'm going to come to derivative rights and enumerated rights a bit later.
Yes.
Lord, I'll get your Lordship's point. I'm going to come to that later. What's an enumerated right and what's a derivative right? What is the status of a derivative right? I'm going to put that proposition. But all I'm saying is, when you say fundamental right to marry, proposition one is it meant marriage in the sense of cohabitation, in the sense of peaceful union. And secondly, once the court says there's a right to marry, that becomes a law. Future legislation will have to take that into account. It can't transgress that unless that judgment is set aside. Now, please come to the next proposition. I'm going a bit fast, if your Lordship.
No.
Prohibits debate in parliament.
Pardon me?
Prohibits debates in parliament.
Yes, as learned solicitor says, that also prohibits a debate in parliament. Once the Lordship has said there's a right to marry, parliament cannot then debate that there is no right to marry. We are going to. I'm just making the proposition. Yes. What's the meaning of a law declared by parliament? And when you say fundamental right to marry, what it means. Now come to Special Marriage Act. Now, if a Lordship comes to the prayers, the writ petition, in my compilation, at page 117, Lord, there are totally 20 writ petitions. And when we decide this list, Lord, the writ petition, we must also bear in mind what are the prayers. And my Lord, my colleague Mr. Amanja has taken the trouble. Please come to page 117.
Of your compilation.
Compilation, yes. Lordship got it, bro?
Yes.
Page 117. Now, just to save your Lordship's time, there are totally, from page 117 to page 125. Now, Lord, this is Kaul has got it, bro?
Just getting it.
Index to come. I'm sorry, but I'll just wait. Lord, out of 20 writ petitions,
Yes.
12, my Lord, Justice Kaul has got it?
Yes.
12 directly challenge various provisions of the Special Marriage Act. Some section 4, 7, 8, 9 schedule. Some want to declare the entire law invalid. Then, Lord, I'll just make a note. Lordship will just kindly note. 117 to 125 are challenges to SMA. 125 to 128 are challenges to SMA plus some other act.
How many in number?
Total 20 writ petitions.
No, 125.
Yes. Now, if your Lordship wants, only SMA 12 writ petitions.
Yes.
Then SMA plus other acts are 13, 14, 15, 3 writ petitions. 13, 14, 15. Then, my Lord, only Hindu Marriage Act are 16, 17, 18, 3 writ petitions. Foreign Marriage Act, 1 writ petition. Citizenship Act, 1 writ petition. Lord, I've just summarized, we have summarized to the extent possible what are the grounds of challenge. So now I come on, sorry.
Yes.
So, my Lord, this table will give your Lordship what are the cases before your Lordship, what have they challenged, what grounds they have challenged. Lord, 20, I don't know if any new writ petitions have been filed. I've also not dealt with the interventions, I've just dealt with the basic writ petitions. Now I come to the second point, which is at page 4 of my submissions. Whether the Special Marriage Act is ultra vires Article 14, 19, 21, Lordship can also add 15 there. Now, my first submission is And Your Lordship, just make a note of it. In my compilation, at page 1 to 3, I've set out the statement of objects, but Your Lordship has repeated several times. It's a law to permit interfaith marriages.
Right.
Now, the proposition I'm making to Your Lordship is, if a law has been made to solemnize or legalize interfaith marriages, then the validity of that law made in 1954 cannot be tested on the ground that it doesn't provide or doesn't permit the recognition of same-sex marriage. Whether you apply the Ramakrishna Dalmia test or the arbitrator test, we must test the object of an act by the object for which Parliament made it.
The stated object.
The stated object. In 2.3, I'm come to only one exception where a law made for a particular purpose at that point of time would fail subsequently, and that is the maxim of Cesante ratione legis, Cesante ipsa lex, and that's the reason why Your Lordship struck down or diluted 377, because the section says carnal intercourse against the order of nature, and then the Wolfenden report and medical science clearly said there's nothing unnatural, there's nothing unlawful about it. So the very rationale for the law went. It was on some biblical thing of
In
that.
case a law cannot be struck down on the ground that its coverage is not wide enough to cover
Broad enough.
Everything
everything
that
that
it ought to
be
cover.
covered.
Under inclusiveness. That is governed by just.
So,
Under classification.
Under classification or under
Yes,
inclusion law
yes.
is a valid law.
Yes. And that's been dealt with Ajit Mills by Justice Matthew. Please come to Ambika Mills. Please come to 2.4. Exactly what Your Lordship.
Regulate something.
Yes.
Pardon me?
You don't have to regulate
Everything.
to regulate
Yes.
something.
Yes. Yes.
If you want to give something, it doesn't mean that everybody has to get it.
Correct. Correct.
And that's why the classical statement that it is open to the legislature to recognize the
Degrees
degrees of evil.
harm, and yes.
Degrees on. And what Your Lordship is saying is echoed. I mean, it's
You
by
can
Justice
you can
Matthew at 2.8.
legislate in phases, you can legislate in parts, you
Parts.
can cover a part of a social problem even at a given point of time.
Even in the case of personal laws, this has been used even more.
Yes. Yes.
They said you can do it in phases, looking at this.
What they call the marginal gains. You go incrementally in.
Step by
No.
step.
Sorry.
So you can't
Yes.
challenge a law on the ground that it should have gone much broader or wider than it has.
Yes. But
That's the
yes,
text of the legislation.
why I said so was because most of the writ petitions seek to strike down certain provisions of the Special Marriage Act and Hindu Marriage Act. And I'm saying that, look, these are newly recognized rights. You can't now strike down a 1954 law on the basis of some rights that come later, which I will come to later when I come to it. Now, my Lord, in the light of what my Lord the Chief Justice mentioned, exactly what Your Lordship said.
Alternate judicial response.
My Lord,
Their argument is it will be a disproportionate judicial response, therefore include us.
my Lord, I'm going to use the expression that will amount to judicial retrofitting when I come to it later.
No, but even if they are right in asserting,
Yes.
even if they are right in asserting
Right.
that same-sex couples are entitled to the benefit, I mean, for testing their hypothesis, that a same-sex couple is entitled to the benefit of the institution of marriage. Because as they said, we are not really despising marriage, but we want to have the benefit of the institution. Even so, you cannot challenge a legislation on the ground of discrimination on the ground that it included only a part of the
Exactly.
community within its field.
Right.
That's one argument. And
Right
second,
to association,
Yes.
remember Damayanti Naran.
Yes.
Right to association, in that classical sense, right,
Yes.
is essentially a right to exclude.
yes, yes.
So if you taking your argument, liken marriage like a club, like this is meant for so and so, so and so, so and so. Implicit in that formulation is that those others cannot be made part of this or members of this.
Yes, yes, yes.
And Mr. Datar, there's another reason for it, because in that case, if you strike down the law on the ground that it is under-inclusive, that will not then result in the creation of a law which is broadly inclusive.
It won't solve the problem.
In fact, that's what happened to us when we had this challenge to the distinction between the ages of marriage for women and men. 18 for women and 21 for men. Justice Narasimha and I got that challenge. But the answer was simple. I mean, that's for the legislature to increase the age of marriage of women to 21. If we strike down the age of marriage of 18 for women, you'll have no law on the subject at all.
Yes, yes. Lordship is right. Yes.
That's one of the reasons why an under-inclusive law is not struck down.
Yes.
An over-inclusive law can be struck down because you are treating unequals equally.
The only reason perhaps is if you start a new law and then, for example, let's say you have, you take a class of people and you deliberately omit somebody, then will it be under inclusiveness or you left out somebody? What's the reason? That will be a separate issue.
That is that hyper classification issue.
Yes, hyperclassification. Yes. Of the same genus, then you can't exclude
You
somebody.
can put yourself in that and say this is an artificial wedge.
Yes.
Then that.
Then that. Now,
Therefore, the alternate argument, which is don't strike it down.
That's right.
But read in an under-inclusive law to make it
All these to the
broadly according to
caution.
This is that.
I'm going
Sikkim-
step by step. There are three
No, first we're
interpretative
dealing
tools.
with unconstitutionality.
Milord, there are three interpretative tools.
Second is.
Reading down,
Sorry, you said.
adding words, and the other one is what's called the third category, updating construction. So all these, I'm going step by step. I'm saying first you can't strike it down. That's my first submission. And on under inclusiveness, kindly just see, my lord, the para 2.4.
Ambikan.
Ambikan.
Matthew.
This is
just
Matthew.
Matthew's
This
judgment.
is Matthew.
So shall I skip it, my lord? Or shall
Yes.
Okay,
Yes.
yes. Now lordship will kindly come to same thing in
The doctrine of eclipse
Eclipse also.
eclipse judgment also.
which one?
The doctrine of eclipse.
Where?
Eclipse in the
Eclipse.
fundamental right sense.
Vikaji Naren Dakras.
Which one?
Just Matthew discusses the doctrine of eclipse also.
Yes.
in this one.
Datar, it's a.
Yes. It
Old-
discuss about the companies, whether the company can be a citizen and.
No. Sundaramaiah, if you remember Sundaramaiah.
Yes.
Constitutional prohibition.
Yes.
Then that later, which is that 15, and Deep Chand.
Yes.
Then this is the third one.
Voidable issue and so on.
What happens if a law
Hmm.
infringes a provision of the constitution? Is it stillborn, or does it come at an eclipse?
My lord,
If it comes under an eclipse, then the shadow is removed when the eclipse is removed.
then become proprio vigore.
It's gone and gone forever.
Very
America talks of that
My
because
lord, there is
it deals with
there is a very serious problem in that. I've made an article also, I put it in Bhopal. T.L. Venkatramayar is the author of that question of distinction between a law void for lack of legislative competence
And the
and the
prohibition.
word lack of for constitutional limitations. Now, when the first Pesikaka case came, it came before a bench of three judges.
Three,
There was a difference of opinion. Then it went before five. Justice Venkatramayar, sitting in a bench of three, had made this distinction of between legislative competence and voidness. When it went to five, the five-judge bench expressly said, we don't accept this distinction. In spite of that, in Sundaramaiah, he's brought it back. That's a
That's
sad
why
thing, but anyway, that's now become the law of the
The
land.
departure went into in Deep Chand.
Yes.
Because 13.2 is as much a prohibition
Yes.
to the legislation
Yes.
as in the case of 245.
Lord, in fact, Justice Kaul has reserved a judgment. We argued at great length on the meaning of voidable in the context of Subramanian Swami's case. Lord, you strike down the distinction between that section
Yes,
6A,
yes.
you classification. What happens? The law came in 2004. You strike it down in 2014. What happens in between? Then you got this British concept of the theory of second actor. All acts done in between, what happens? But what I'm submitting is, I'll just skip this question of under inclusiveness. Same thing was mentioned in Navlaka's case, which is at page 5. Right? So under inclusiveness, so I'll skip that. Lordship knows the proposition.
Go ahead.
Now come to para 3, third part of my submissions. What are the limits to altering provisions of the Special Marriage Act? Now, Lordship will kindly cease to start my motion. Yes. Now, if your Lordship kindly sees, some of the prayers say, and I think Mr. Mukul Rothgi's submission also says they gave a chart. Replace this word here, replace that word here, and then you will get the solution. Sorry.
Just
No, sorry.
at that extract, a judge must not alter the material of which the act is.
Point
The
of-
governed.
C4 code as
The point of discuss-
doesn't repeat it
This
again.
all seems to be locked out.
Yes.
There is no use that.
No, it's
No, it's there, it's there.
No, I think it's Lordship's.
frozen.
Yeah, you're right. I don't know if he's
The frame is.
willing.
Sanjay, they could also buy it.
Yes.
There's a call, you are,
Frame is frozen, that's correct.
I think there is.
yeah, that is, the other call is on.
Yes.
Yes.
Yes. Now, Manoj, there I mentioned the famous oft-repeated case of Lord Denning. In fact, more equally beautiful than this, he says that English is not a perfect language. If you could, then it will be a divine prescience and so on. Then this last passage starts. So my next submission is, if you accept the written submissions of the petitioners, and start making changes, you're completely altering the fabric, which is not permissible by a court. Now, please come to what exactly happened in this case. In one case, there's a question of the court said that the right to speedy trial is part of Article 21.
7 judges.
Then it went to a further point. What is speedy? How many months is speedy? Then the court said in 2 cases, they said specific time limits. If the trial goes beyond this point,
2 years.
then the whole. And number of people started getting acquitted. Then what happened? It went to a bench of 7 judges in Ramchandra Rao. And I think Justice Raju took a dissenting view, but 6 judges held.
Justice Lahoti is.
Yes.
Justice Lahoti's judgment, Lordship is right. Justice Lahoti's judgment, they held that however desirable this speedy trial may be, the court can't lay down a parameter and say, no, this is the time limit. And then he quotes Wade's monograph, which is worth extracting. Kindly see, my lord. And that is the reason which I will take me to the next thing of polycentric disputes.
Lon Fuller's,
Pardon me?
Lon Fuller's.
Lon Fuller's Spider's Web, yes. Your lordship has quoted it also in one. There are 3.4. Please see, my lord. I would like to read this, my lord. The majority opinion delivered by a 7-judge bench of this court relied upon a cautionary note featured in the monograph Judicial Activism and Constitutional Democracy in India, which highlighted the difficulties the court would encounter while venturing into the domain of the legislature. It held in a monograph, Judicial Activism and Constitutional Democracy in India, recommended by Sir William Wade as a small book devoted to a big subject, the learned author, while recording appreciation of judicial activism, sounds a note of caution. It is plain that the judiciary is the least competent to function as a legislative or administrative agency. For one thing, courts lack the facilities to gather detailed data or to make probing inquiries. Reliance on advocates who appear before them for data is likely to give them partisan and inadequate information. On the other hand, if the courts have to rely on their own knowledge or research, it is bound to be selective and subjective. This is very important. Courts have also no means of effectively supervising and implementing the aftermath of their orders, schemes, and mandates. Moreover, since courts mandate for isolated cases, the decrees make no allowance for differing and varying situations which administrators will encounter in applying the mandates to other cases. Courts have also no method to reverse their orders if they are found unworkable or requiring modification. Highlighting the difficulties which the courts are likely to encounter if embarking in the fields of legislation or administration, the learned author advises the Supreme Court should have well left the decision-making to the other branches of the government after directing their attention to the problems rather than itself entering the remedial field. Yes. Now, my lord, here I want to mention that here, my lord, I've got
Sometimes there is one of the very distinguished lawyers here is to make this argument that if the court gives a declaration, which essentially is part of the legislative domain, and declares that this is possible and this should not be done, there is no manner for a citizen to come and say this is wrong, because that's part of.
yes, yes. I'm going to come to, I want your lordship to lay down some law on what's the status of derivative rights. There's no such, but I'll just make my submissions. I'm relying on an article by Sirwai, but kindly see. Now, my lord, here I want to mention, stopping here for a minute. What?
Void.
Possibly, Mr. Sirwai, possibly what your lordships indicate.
The previous Attorney General said that. He used to make this argument.
Yeah.
Yes, Mr. Datar. Mr. Datar, 7 minutes to go. Huh?
I don't know if I'll finish. I'll try my best.
We'll wrap it up by 4 o'clock.
I'll try to, okay, I'll try and wrap it up. Just give me 5 minutes more, my lordship. Yeah. No, here I'm going to submit. If a lordship takes Vishaka was a guideline, but the Union of India accepted those guidelines. Take triple talaq. In the minority judgment of Kher and Justice Nazir, they said, yes, the Union accepts that this is the correct position, striking down is correct. And also the All India Muslim Personal Board filed an affidavit saying the Qazis will be advised to tell the bridegroom not to enter triple talaq. So this is a concept of collaborative governance, where when the Supreme Court makes a declaration, filling up a vacuum or giving some general guidelines for the welfare of the people, if the union supports it, then it becomes a concept of collaborative governance. But if the union is opposed to it, my lord, then my humble submission is those guidelines should not be issued. And here what I'm submitting is, Lordship will have to bear the difference between Article 141, where Lordship declares the law, whereas the making law is 246. And there's an ocean of a difference between declaring a law under Article 141 and making a law under 246, 247, etc. Now, Lordship will kindly see on para 4.
Correct.
It's coming in polycentric. Lord, I won't take time on this limits of reading down, updating construction. Lord, Mazdoor Congress says you can read down, but you can't do the exercise if the provision is cast in a definite and unambiguous language. And my submission is the Special Marriage Act, the Hindu Marriage Act are very clearly cast. None of them call for exercising of the interpretation of reading down, adding words, or updating construction. Lordship will just make a note there. Para 4.1, 4.2, 4.3 are in the context of addition of words. Then 4.4 is updating construction. And much was made about the Madras High Court judgment of Arun Kumar, where they say the male pronoun is directly contrary to Madhu Kishwar in para 4.5. Now come to polycentric disputes. Now, Lord, this lawn full of spider's web, and why do I call it a spider's web? Lordship has to visualize entry 5 of list 3. It contemplates marriage, divorce, adoption, wills, intestacy, succession, joint family, partition, and other issues where customary law prevails. Lord, I did a search. I put husband or wife in SEC. I got 542 hits in 542 places in different statutes. Some are, of course, repeal statutes. Put spouse, it comes in 233 places. So now, my Lord, when your Lordship is going to decide, if your Lordship is going to put, as they prayed for, words into Special Marriage Act to give them recognition, then you are virtually entering into a polycentric dispute. Navtej Johar was monocentric, only 377. Shafin Jan was monocentric. Joseph Shine was monocentric. But this is a polycentric dispute where a large number of cognate provisions will be involved, and one cannot predict today what will be the side effect or the collateral damage or the collateral impact on other statutes. Now, my Lord, 4.10 is, my Lord, the Chief Justice has referred to lawn fuller with approval in the OROP judgment, my Lord. Now, finally, I come to enumerated and derivative rights. My Lord, I finally come to enumerated and derivative rights. Lordship said, what is the right to marry? Now, my submission is, right from A.K. Gopalan, it was settled law that part 3 are not exhaustive of all the rights. Justice Das's judgment is there, Dasgupta judgment. And subsequently also other judgments are there where it's not exhaustive. Now, right to life has been the source or the some kind of a Gangotri of so many rights, the fountainhead of so many rights over the years. Now, what is the status of these rights, derivative rights? Now, these derivative rights were first discussed in All India Bank Employees Association, where they said 62. Where, my Lord, Justice Rajgopal Iyengar.
I know what you're saying, where he says that your right doesn't include the fruition of that right.
Yes. I got the right to form an association, but that does not mean that the Bank Employees Union has the right to ask for the accounts of the company so that they can decide how much more bonus they can claim. So he says that your right is to form an association, but you can't get automatically the right to make that basic right complete.
Fertilizer Kamgar Union also then took that.
Yes. And Maneka Gandhi quoted All India Bank with approval. I've quoted both those points. And therefore, my submission is, Lordship will just take seed-wise article. And this is a new point I'm making, your Lordship may kindly see, because Lordship keeps on evolving rights.
Where is the reference to seed-wise article?
Seed-wise article is at page 39 to 53 of my book. I'm just trying to meet the 4 o'clock deadline.
The compilation.
Yes. Kindly come to page 48 at para 17. It's a wonderful article written in the context of the Privy Purse's case. Of course, Mr. Sirvai felt the Sirvai Privy Purse's judgment was wrong. Why I use this? I was trying to find out. Lordship says there's a right to shelter, but it can't be implemented. There's a right to, Lordship just now mentioned, right to education. What follows? I may declare right to marry. Then what happens? Right to roads, right to housing.
Does that mean that you don't recognize that right?
Yes, what I'm submitting is you recognize the right, but I'm putting a proposition that once you recognize the right, future laws must take that recognition into account. But there could be some derivative rights. Suppose Lordship says right to life includes right to shelter. In the Hoffeldian sense, it will not carry a corresponding duty that you must provide housing. So some derivative rights, and there are two categories of derivative rights.
From our constitution lexicon, you will say this is somewhat like a directive principle.
Directive principles.
Yes,
The lines of.
yes. Directive principles who are born out of a fundamental right. They, my lord, if you read minimum ills, they make very clear these are the desired goals of this thing. Here you say it is a right. If I got a right to life, I got a right to housing, I got a right to shelter, I got a right to food. All these are rights. Now these rights, there are two types. One are rights which are inextricably intertwined with the main right. Right to free speech and expression. In Romesh Thapa, they say right to publish is part of free speech because the Supreme Court said you want to publish what you think, you don't want to talk to yourself. So that's an integral part. There are some rights which are derivative rights, which are derived rights, which I'm humbly submitting can be inchoate rights because, as Sirva explains, there are certain rights which are exception to the concept of ubi jus, ubi remedium. There is a right, but there is no enforceable remedy. Mr. Sirva mentioned in the context of this thing. Now, my lord, I'll just make my last submission. Yes, that's okay. Just 5 minutes, my lord.
Yes, Mr. President. The last submission.
Yes. Now, my lord, so there I mentioned about All India Bank and so on. Now I come to this by submission. If your lordship sees the Arbitration and Conciliation Act, surprisingly, in the 7th schedule, lordship will just make a note.
Yes.
In the 7th schedule to the Arbitration and Conciliation Act, conflict of interest, they use the word explanation 1. Kindly say explanation 1.
Seventh schedule explanation or
Explanation 1 in the 7th schedule, after para 19.
Yes, one. or
Lordship
two.
has got it?
Yes,
The term close family member refers to a spouse, sibling, child, parent, or life partner.
yes.
So they use spouse differently from life partner. So an arbitrator, perhaps if he's gay, and if his life partner is gay, then it becomes a conflict of interest. So spouse is not necessarily inclusive of the life partner. My lord, I will conclude my point just mentioning that the decriminalization of same-sex, your lordship's judgment in Navtej Johar, was really a historic moment. It will be a jewel in the crown of the Supreme Court, and I mean it, my lord. It's a huge impact of reading down a biblical-based law, which is completely anachronistic to a constitutional democracy. The lordship declared that these people can live in peace. They will not be prosecuted under 377. They will have the same rights as all of us to live in peace, harmony, nobody disturb them. But my humble submission is, making that declaration is the constitutional border of the judiciary. Now, what rights further people, the same-sex couples must have? You enter the territory of the legislature under Article 246. Decriminalizing is 141. Developing it further is 246. And my humble request is, if your lordship now wants to include, answer the prayers, read different sections into Special Marriage Act, Hindu Marriage Act, I would use the expression, it will amount to judicial retrofitting. The definition of retrofitting is to fit a new part or a new component into an old machinery. Now, the recognition of right to marriage, the recognition of this right of same-sex couples, that there's nothing unnatural about it, they can live in peace. These are newly recognized rights, and it will be dangerous and lead to adverse consequences if these newfound rights are retrofitted into old statutes. My humble request is that prayer should be declined and the writ petition dismissed.
Thank you, Mr. Datar. So tomorrow morning, we'll commence with Ms. Aishwarya Bhati, then Mr. J. Sai Deepak. And sorry, Manisha will argue, Manisha Lavkumar will argue, and then Mr. J. Sai Deepak. We request each of you to take 20 minutes tomorrow morning. So that will take us to about 12:15 tomorrow. I think the interveners, what solicitor will do is, interveners may all put together maybe one-page notes, and they move over to Mr. Kanu Agarwal, and then he will just tender it to the court. So the interveners will now will be down to one. All right. So what we are planning to do is 20 minutes each to Ms. Bhati, Ms. Manisha Lavkumar, and Mr. J. Sai Deepak, which takes us for 1 hour. If Mr. Maninder Singh does not have greener pastures, another 20 minutes from Mr. Maninder Singh when he makes his presence here. So that takes us to about 12:35 tomorrow morning. So
Lord,
12:30 we should.
Been said the road to heaven is.
Lord, your lordships may perhaps, my lord, consider not to restrict it that, my lord, closely.
We done that, but if you don't do it today, we'll never be able to do it tomorrow.
Your lordships are.
All right, but the
I'm
upshot of it is
clarification
that
statement.
at lunch tomorrow, we will wrap up the hearings from this side at lunchtime. Solicitor, for 5 minutes, you spend time and ration time between you all.
My lord, I'll speak to them and, my lord, revert in the morning.
Also, as just Bhat says, if everybody need now read out extracts from judgments, etc., you can just give us a note, refer to the point. That's what Mr. Sibal, Mr. Datar also did today. So that really saved a lot of time when Mr. Sibal and Mr. Datar were arguing. So we request everybody else who follows also to do the same thing. If we have the reason why we said this way, we conclude by 12:30. Is that if you have some people who are left, we don't want to give the impression that we didn't hear someone. Somebody can argue for 2
Your
minutes,
lordship
3
would never
minutes.
give that impression.
So 2 minutes, 3 minutes, 5 minutes, at least there's a feeling that we heard the perspective. So, but so long as we have it at the back of our mind, and then between 2 o'clock and 4 o'clock, one of you will please sit down and ration time amongst yourselves so that between all of you in 2 hours, we'll wrap up.
Exactly. The road to hell is paved with good intentions. We'll try to do it in 2 hours, but
2 hours tomorrow, yes.
we'll try.
We've now heard the entire controversy. We just have a very great.
Grateful, man.